I was looking through some of the candidate questionnaires that you and a few others had, I think to different Democratic parties. And I saw that you had wrote that the courts have to start with the Constitution, and that if legislation crosses the line, it should be declared unconstitutional. Was wondering how that philosophy shapes your approach to, say, voter approved legislation or legislation enacted by the legislature that pushes constitutional boundaries.
Well, certainly if that comes to the court, there will be arguments on both sides. And some will be saying the Constitution says this, and therefore this is allowed. And some will be saying the Constitution doesn't allow this, and here's the authority for that, and here's the precedent for that. And so I would consider arguments on both sides. Look at the Constitution and read it myself and understand that different people can read different meanings into the same words. Obviously, we have a court system for a reason, because if everybody read the same thing the same way every time, we would be out of a job. But where there is a dispute, where there is clear ambiguity, then you look at how it's been interpreted in the past, and then you look at whether there's been a mistake in the past. We have a history of sometimes interpreting things the wrong way, and that's why the Supreme Court is has the mandate, if you will, to overturn past precedent. What's the process and what do you weigh? I have to say that's a case by case analysis. Sometimes it's going to be very obvious because the Constitution says this and the legislation says this. Sometimes the question will be that, well, the Constitution says this broadly. How does this specific term either fit into or not fit into? And I think the analysis is depending on the case and the argument.
Mhm.
So if I'm approaching that decision, I will read, understand, research, not substitute my own judgment for that of the arguments in front of me, but be persuaded by the one that I think is the most in line with the Constitution as written or what is clearly intended. Reasonable minds will disagree on that, and I will give it my best judgment in the time.
And I know you can't say how you would rule on a future case or an issue likely to reach the court, but looking at some high-profile decisions in the past, like the Blake decision, in the Quinn decision in 2023, how should voters understand how you would consider cases where president, constitutional text, public safety, and tax policy, all this legislative intent collides?
You know that's 16 questions in one, right?
Yeah.
All right. Well, where legislation collides with precedent, we have precedent that says precedent isn't overturned unless it's wrongly decided and currently harmful. And then there has to be a real live controversy and there has to be someone withstanding. So just because there's a law that may in fact be constitutional on the books, it doesn't come before the Supreme Court until or unless there is a case and a litigant that challenges that. So it's not like any Supreme Court justice just gets to clean house and say, da, 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 da. The cases have to be brought by people who've been harmed by them or have standing. And then that comes to the court. What does the court do in evaluating precedent? I guess we have our own precedent about when that is appropriate or not. Not to not answer your question, but to say that the process, I think, is the same no matter what the issue is. And if it's, again, legislation based or whether it's a case that interpreted legislation, again, if it was wrongly decided and it's currently harmful, the Supreme Court has the duty to fix those decisions. And sometimes that happens decades later. Sometimes, probably more rarely, it can be a faster turnaround to adjust something that was wrong to begin with. But in any human system, human error is made, and the beauty of our system is that we have a mechanism for fixing that. But that mechanism shouldn't be like a whipsaw where you're just going back and forth every change in administration, every election. Now we have
Mhm.
different precedent. Now we have different laws, different decisions. I think the predictability, consistency, and stability of the court system and judicial decisions is important so that litigants and attorneys know what to predict under similar
Mhm.
circumstances and get the same kind of ruling under the same kinds of facts. So no two cases are identical. You should have some reasonable expectation of the range of outcomes in order just to function as a society of laws.
Are there parts of the Supreme Court's reasoning in either the Blake or Quinn cases where you think voters should pay closer attention to when assessing candidates ahead of August?
That is an area I'm going to decline to
Hmm.
comment on because Quinn, of course, had to do with the capital gains tax. Now we have perhaps similar, perhaps not so similar income tax legislation coming on. So if I were even to point the public to this, it would
Hmm.
indicate, hey, I disagree with the majority. I agree with I can't put myself in that box because I need to maintain neutrality so I can hear all arguments without having predetermined which ones I like. I'm
Can
sorry.
you no, can you explain that judicial rule for voters? Because it might
Mm.
be a surprise to most people to read, like, hey, the income tax is front and center this year, but they can't even talk about it. Can you
Nobody
explain that
can.
rule and then also the limits that you guys have in soliciting donations? Because I know you guys can't personally solicit funding as well.
Yeah. So the Code of Judicial Ethics is what governs judges and candidates for judicial positions. And it restrains us from, let's start with the donations, soliciting personally any donations. I
Hmm.
can't ask people for money. And I think the idea is, well, we shouldn't be buying our justice, right? There shouldn't
Hmm.
be the appearance that because I contributed to this campaign, therefore this judicial officer owes me something or is likely to make a decision that favors me or my business or my group interests, whatever they are, because they asked me for money and I gave it to them. I looked them in the eye and I know exactly what our understanding was.
Hmm.
Okay, so that does tie our hands a little bit because in trying to do fundraising for a campaign, a third party has to make the pitch and has to make the ask. And obviously, the public disclosure requirements show who gives any amount unless it's under $100. So there's full disclosure about who's supporting which candidate. That's a restriction on us. The other restrictions that we cannot promise or comment on issues or possible cases that may come before us. And I think that's also important because if I said, gee, I don't want to pay any more income taxes in the state, I don't want to pay any more taxes in the state of Washington,
Hmm.
I don't want another tax, and I go into a case with have that comment out there in the public, then people are going to think when I make a decision that's in favor of that outcome, oh, well, she's pre-decided it and we knew it and that's why we voted for her. That actually creates a partisan judiciary. And if this is a nonpartisan race and we want the judiciary to remain nonpartisan so that it can be the checks and balances for the two partisan branches of government, the legislative and the executive, well, then we've lost the the point of these separation of powers and the checks and balances because then it's just one party controlling everything. So that's why it's important not to comment on things that could come
Hmm.
before the court. And to your point, any case that you bring up in theory could come before the court in a 2-year term or in a 6-year term
Hmm.
because there could be a case that arises and works its way up. And if the Supreme Court has authority to overturn any prior decision, it pretty much means that anything that's commented on
Hmm.
could create again that appearance of conflict or the appearance of prejudging an issue and therefore having a closed mind when the case actually comes before the court. Thanks for asking that. It is really hard to say, okay,
Hmm.
look, vote for me. I can't promise you anything. I can't ask you for money. I can't do anything but say, well, then why are we running? Well, you run on experience, you run on character, you run on the person you trust most to make the decisions in the moment, to do the work, and to do so without owing anybody any favors or even appearing to have a conflict of interest.
Do you
That's
think
what I'm emphasizing in my
uh,
campaign anyway.
Sorry to interrupt you there. Do you think the state Supreme Court, as it is right now, or the situation it's heading, do you think we already have a partisan judiciary, or is the way recent appointments have been made, do you think that raises potential concerns or flags around a partisan judiciary?
Where I think some partisanship comes into play is just by the nature of the constitutional authority given to a partisan elected governor to appoint justices for a term when a prior justice retires. what happens and has happened in this election is two of our justices have retired before the end of their term, which gives Governor Ferguson, gave Governor Inslee, gave Governor Gregoire, any governor has the opportunity to appoint their replacement. Well, then that replacement, you might say, has a little bit of a leg up in the next election, even if they have to run, because now they're the incumbent. And to the average citizen, the incumbent somehow already earned the job, is maybe doing an okay job, or they don't have a reason to complain because they don't feel the effects of those decisions. And often incumbents don't get opposed in elections. They're just on the ballot. And so that becomes a way where a partisan governor, not to use the term stack the court, but can stack the court, can essentially handpick those justices who then still have to run for election. And that's what's going on in my race. There is an incumbent who's been on the bench for 5 months, appointed by the governor. I want to give the voters of Washington a choice. We don't know what went into the governor's analysis about why he picked this person. So the voters should determine the best candidate to be their own elected justice in the Supreme Court. If you look at the current state of the court, six of the nine Supreme Court justices started their terms by appointment, all from democratically, well, Democrat, partisan
Mhm.
Democrat, by Democratic governors as opposed to Republican governors. They were all democratically elected, but they were part of one party versus another. Does that mean that they are leaning in a partisan direction? I think the fact that five open seats in this election are getting so much attention and press is that at least some voters in Washington think so. I personally know that any judicial officer I've encountered on any level of any court is mostly there for the right reasons, doing their best and doing the right thing. But as you can see in a society, we have a broad spectrum of perception about what the right thing is, the right way to go about it, the policies that are implemented, and the like. And so that's the long answer to that partisan question. I don't think it's non-existent, but
Mhm.
I'm not going to slap an overarching label on any individual justice because I know that well-meaning people still can disagree on how decisions are made.
So the two recent appointees, one your opponent Justice Colleen Medley, and then Theo Angelis in position five. Theo worked with Governor Ferguson at K&L Gates, and Melody had worked under Ferguson when he was the Attorney General. Some might argue that, look, they have valuable experience. That's something that you would want in a position like this. But at the same time, it's very close. Do you think that it's getting too close for comfort in terms of those appointments, or how should voters assess that situation?
In my opinion, if I were in the shoes of Justice Melody and I had worked closely with the now governor and the governor signed legislation that's now before me, I would not be comfortable trying to evaluate that case because of the appearance of a conflict of interest. I would recuse myself. I can't imagine my own former boss. I worked with Michael Buney at Michael Buney and Associates at the first 17 years of my practice. If he had a case that came before me in the Supreme Court, I would recuse myself in a heartbeat because there's just a relationship at the water cooler or informally or something that goes beyond even the work bounds. I question, if you will, it's a dangerous thing to say. I question a governor who would think these appointees are great picks if he has worked closely with them and knows that there is at least the appearance of a conflict of interest if, again, legislation that he signs come before them. Surely there are any number of qualified judges and attorneys in Washington state that he has not worked closely with, that he could have chosen that didn't have that close personal connection. So there's something there that I
Mhm.
think is worth questioning as to loyalty. We are not a society where loyalty trumps all. It should be experience, impartiality, and what voice do you bring? What perspective do you bring to the Supreme Court, as opposed to what loyalties have you built up in your career?